Everything that is explained in this video is summarized from CoinMarketCap. And also, please don't forget to support my channel for more XRP updates and some other cryptocurrencies as a whole. Now take a look at this. Ripple versus SEC. Ripple's path forward after SEC appeal. The chief legal officer of Ripple Inc., Stuart Alderoty, went to Twitter to bring attention to a key development in the appeal of the SEC's Govil case. This important development has the potential to greatly impact the lawsuit that Ripple Inc. is now engaged in with the United States Securities and Exchange Commission. The tweet from Stuart Alderoty. In a tweet, Alderoty draws attention to the significance of the decision made by the Second Circuit Court of Appeals in the case of the Securities and Exchange Commission versus Govil, Gesada considered. In his statement, he draws attention to an essential component of the decision, which is that if a buyer suffers no financial loss, the SEC is not entitled to disgorgement from the seller. In particular, this comment resonates with the tension that is currently present in the CC's illogical demand that Ripple submit a $2 billion file for the unregistered contractual sale of XRP coins and the profit that was obtained with them. The perspective of Bill Morgan, a lawyer named Bill Morgan, offers a more in-depth analysis of the position taken by the SEC and the potential impact it could have on Ripple in response to a tweet posted by Alderoty. Morgan elucidates the use of the government decision by the Securities and Exchange Commission's commission, highlighting the agency's pursuit of disgorgement based on purported financial harm to investors' interests. Morgan states that the Securities and Exchange Commission asserts that if Ripple had registered the sales, it would have been required to disclose the discounts that were offered to favored institutional investors to non-favored institutional investors. This would have enabled the non-favored institutional investors to negotiate better terms. It is possible that even if they did not incur losses, they could have done better, as per the statement. Ripple's legal defense has been given a boost by the fact that the SEC's appeal in the Govil case was unsuccessful. By utilizing this verdict, Ripple has the potential to counter the claims made by the SEC concerning losses incurred by institutional investors and the grounds for disgorgement. It is also worth noting that Sam Bankman-Fried has fought back and appealed a sentence of 25 years for fraud. Both the tweet on the part of Stuart Alderoty and the thoughts provided by Bill Morgan provide significant perspectives on the changing legal landscape and the consequences it has for Ripple. It was brought to light by yet another lawsuit filed by the SEC against a cryptocurrency company that the SEC will continue to regulate through enforcement. The Securities and Exchange Commission continues to file complaints against cryptocurrency companies despite the absence of a defined regulatory framework in the United States. Uniswap was supported by the cryptocurrency community, which observed the most recent action taken by the SEC. This is what Paul Grewal, chief legal officer of Coinbase, had to say about it. There are times when you have to laugh because if you don't cry, what is the best way to reconcile the Securities and Exchange Commission's SEC assertion that Uniswap functions as a broker with the decision that the SEC just a few days ago, you are unable to do so? Marvin Amori, chief legal officer of Uniswap, made a reference to a recent court verdict in the case of the Securities and Exchange Commission versus Coinbase. By the legal definitions of securities exchange and broker, the Uniswap protocol, web app, and wallet do not match the requirements. The court that presided over the case of SEC v. Coinbase disregarded the notion that cryptocurrency wallets were brokers, even if the tokens in question were securities. This decision was made just a few weeks ago. A portion of the motion to dismiss MTD filed by Coinbase was granted by Judge Catherine Fillet in March. The charges that were brought against Coinbase Wallet were dropped by Judge Fillet. On the other hand, Judge Fillet did not grant the motion to dismiss the accusations that were brought against Coinbase for operating as an unregistered securities exchange. While Uniswap was making news, the Securities and Exchange Commission SEC was unsuccessful in obtaining another significant court verdict this week regarding the SEC's Ripple lawsuit. There were no new developments to take into consideration on Thursday. There is a possibility that Ripple's arguments against severe punishment for violating securities rules could be strengthened by a court finding that is unconnected to the matter. The chief legal officer of Ripple, Stuart Alderoty, disseminated the information of the ruling, writing, the SEC is continuing to suffer defeat. The ruling that was made in the case of Govil, which said that the Securities and Exchange Commission is not entitled to disgorgement from the seller if the buyer does not suffer any financial loss, was not reconsidered by the Second Circuit Court of Appeals. The verdict may affect the SEC's attempt to demand a disgorgement of $2 billion in the Ripple case. A ruling by the 2D Circuit Court, which is also known as Ripple, stated that the Securities and Exchange Commission is not permitted to request a crippling disgorgement award without first demonstrating that investors have suffered genuine financial injury. SEC's defeat in the appellate courts comes at a particularly distressing time. As of the 22nd of April, Ripple is required to submit its remedy-related opposition to the opening brief of the SEC. Ripple may cite several instances, one of which will be the SEC's Govil case. Aside from establishing the financial harm or lack thereof, Ripple will also provide specifics regarding the sales of XRP to institutional investors in the United States and other countries. The Securities and Exchange Commission spurged for a punitive penalty in the opening brief, alleging that Ripple continued to violate its securities laws after the lawsuit was filed in 2020. However, in the case of Morrison versus NAB, the Supreme Court of the United States decided that the Securities and Exchange Commission only has authority over sales that take place within the United States. There was no indication from the SEC as to whether the post-complaint sales of XRP were to institutional investors in the United States or abroad. Furthermore, if the majority of pre-complaint XRP sales were made to institutional investors located outside of the United States, the proceeds from sales in the United States would be much lower than the overall proceeds of $770 million from XRP sales. As a result of yet another action brought by the CSE against a cryptocurrency company, it became clear that the SEC will continue to govern through enforcement. SEC filings against cryptocurrency companies continue despite the absence of a defined regulatory framework in the United States. The cryptocurrency community scrutinized the most recent action taken by the SEC while standing in support of Uniswap. In his statement, Paul Grewal, chief legal officer of Coinbase, said the following: "When you're feeling down, it's important to remember that you need to laugh. When the Supreme Court's decision against the Securities and Exchange Commission SEC was handed down just a few days earlier, how can one reconcile the SEC's assertion that Uniswap functions as a broker? The answer is that you cannot." Uniswap chief legal officer Marvin Amorim made a reference to a recent court verdict in the case of the Securities and Exchange Commission versus Coinbase, saying, by the legal definitions of securities exchange and broker, the Uniswap protocol, web app, and wallet do not meet the regulations. Even though the tokens at issue were securities, the judge in the case of SEV Coinbase disregarded the accusation that cryptocurrency wallets were brokers. This decision was made just a few weeks ago. A portion of the motion to dismiss PT filed by Coinbase was granted by Judge Catherine Fella in March 2019. It was decided by Judge Fella that the allegations against Coinbase wallet should be dismissed. Coinbase was operating as an unregistered securities exchange, and Judge Fella did not grant the motion to dismiss the allegations against the company. The Securities and Exchange Commission, SEC, suffered yet another significant setback this week.